Hello and welcome to the LLG Grapevine podcast. You're listening to Helen Bennett, LLG's Executive Director of Policy and Governance, and Dennis Hall, LLG Bulletin Editor.
Hello, everyone.
Busy week this week, Dennis. I've been taking a look at our programme. We have our leadership conference on Thursday, and it's excellent, actually. We've got Amadip Somal, the Local Government and Social Care Ombudsman, on how the Ombudsman supports good governance and leadership in local government, and Zara Mohammed, who's the former Secretary General of the Muslim Council of Britain, and she'll be talking about women in leadership, the challenges they face, and the resilience required to succeed. On our membership events side, we have the Southern Regional Meeting, the Junior Professional Group Meeting, and the Planning National Lead Meeting. So plenty of opportunities to get involved. But let's return now to the local government landscape. What's on your agenda, Dennis?
Well, Helen, I'm turning first to that Procurement Act 2023, which came into force last Monday. What should contracting authorities be doing, or should they have done by now? Procurement rules in the UK are on the cusp of significant reform. The Act introduces extensive changes to public procurement processes, with the overarching aim of simplifying these procedures and enabling greater accessibility for businesses, and particularly small and social enterprises, to compete for public sector contracts. So, here's the first question: preparing for those changes. Well, both suppliers and contracting authorities must take steps to ensure that they are ready to navigate the new procurement landscape. The changes present opportunities, but also demand meticulous preparation to avoid key operational disruptions.
Well, I understand that key actions for contracting authorities, certainly one of the immediate priorities for contracting authorities, is getting to know the central digital platform, the new system designed to centralise procurement processes. I understand the onboarding and registration phase ended in January 2025. Contracting authorities will need to align their operations with the new regulations. But Dennis, there are probably, I think, 6 key preparatory steps to follow you've identified.
Yes, indeed they are, and you know how much I like lists. Item 1, testing system updates. You should ensure updates to IT systems are thoroughly tested. This includes functionalities for publishing new notices, tender documentation, and contract awards under these new rules. Second, updating procurement templates. Revise standard procurement and governance documents. This should account for contracts falling under both the existing regime and the new Act to avoid procedural inconsistencies. 3, incorporating new evaluation criteria. Update evaluation and award criteria to reflect the Act's new emphasis on broader public benefits, including social value, sustainability, and innovation, as well as processes to manage potential exclusions. 4, revising those timelines. Assess existing timelines and planning cycles for upcoming projects. Early market engagement will be critical to accommodate these new requirements. And next, enhancing transparency in contracts. Amend contract documentation to incorporate the enhanced transparency obligations and termination rights. And this includes ensuring readiness to publish contracts, report performance metrics, and managing exit in light of implied termination rights. And finally, tracking those KPIs. Establish processes to monitor key performance indicators and delivery outcomes for projects awarded under the new framework. But the Act, as I said, came in last week, so you've already done these things, haven't you?
Well, LLG certainly wish our members all the very best with the transition. Now, a review of One Housing following an Ombudsman investigation has unearthed over 800 entries of incorrect asbestos risk data. For those who don't know, asbestos was historically often used as a building material for installation for buildings, boilers and pipes, roofing and flooring tiles, and therefore can be found in many homes and buildings. Indeed, reports have found up to 1.5 million UK homes may still have asbestos, especially those built before the late 1980s. As most of us know, if intact in a property, the risk is very small. However, if asbestos is disturbed or damaged in some way, fibres may be released, which can have several adverse health effects. And we, of course, have seen examples in schools and public buildings, including councils.
Well, this is really a concerning case, and the Ombudsman issued a series of orders to the landlord following a severe maladministration finding, and that's the most serious finding it can make. And that finding was in respect of an investigation into its record keeping for repairs and the presence of asbestos in a resident's home. The complaint followed a leak and collapsed ceiling in a resident's home. Repairs took 14 months, and the landlord did not have accurate and up-to-date records about the presence of asbestos in the property. The landlord did not assess the condition of the asbestos and could not evidence that it considered temporarily moving the family.
Well, the Ombudsman's power to order a review of a landlord's policy or practice is an intervention that can be used where there could be repeated service failure to other households, and the wider order aims to improve services for other residents. So the landlord's review found, as I've said, over 800 records of incorrect data on its asbestos register, and the risk scoring system showed several properties as no risk where it had no data, when in fact there could be asbestos present. And it also showed that some properties had been marked as high risk on the register where old data had not been removed. The review found the inconsistencies in its data had been caused by multiple factors, including external services being brought in-house and its knowledge and information management. This included new information being added without existing records being updated when moving to the new system.
Well, One Housing did issue a statement in which it said that it was, and quote, very sorry for the distress caused to their customer following a leak and the collapsing ceiling. And it apologised too for the repair handling, the record keeping, and also the complaint handling. In this case, the company say they undertook a detailed investigation and a lessons learned review. They revisited the home 6 months later to make sure that the key learning points were being implemented.
Well, there's lessons for us all in this, isn't there, Dennis, when switching over systems, and perhaps a good reminder to review policies and procedures held by authorities. Now, AI is always in the news, especially the legal news, but how good is it at this point in time, Dennis?
Well, Helen, we may have an answer to that question. AI tools could be reaching the stage where they could be used as a cross-check for lawyers working on a legal issue, a new report has concluded. Testing by Magic Circle firm Linklaters found marked improvements in how large language model LLM machines were able to answer questions about different areas of legal practice. The responses were still not always right and lacked nuance, despite advances having been made. But the firm's report on its findings said AI tools should not be used for English law legal advice without expert human supervision. But the report added, if that expert supervision is available, they are getting to the stage where they could be useful, for example, by creating a first draft or as a cross-check. And the report went on, this is particularly the case for tasks that involve summarizing relatively well-known areas of law. In contrast, their ability to apply the law to the facts or interpret clauses is less good. Researchers asked questions that would require advice from a competent mid-level, that's to say 2 years post-qualification experience, lawyer specialized in that practice area. And the LLM's answers were marked out of 10 by senior Linklaters lawyers, comprising 5 marks for substance, 3 for whether the answer was supported by relevant statute or case law, and 2 marks for clarity.
Well, I tested this at the weekend, Dennis, when I was doing a bit of research, and I have to say, it was coming back with quite a lot of out-of-date law or, frankly, wrong conclusions. And I think if you were a layperson trying to rely on it, I think it could get you into a lot of trouble because you need that skills, knowledge, and experience to be able to spot where it's going wrong. But
you do need that supervision.
Absolutely. And the last benchmarking exercise on this, which I understand was back in October 2023, had revealed major flaws in the models tested, with mostly wrong answers, as I've said, and worryingly some fictional citations. And Linklater said it would change its methodology after feedback to offer more sophisticated prompt engineering. And lawyers noted that it felt like the AI tools had tried too hard, in many cases producing the right answer, but alongside a lot of extra and duplicative material. The report said that one potential problem is that the eagerness of the models to provide a clear answer led them to overstating the confidence of their advice.
Interesting. And the report concluded that even if flaws in AI technology are ironed out, this does not necessarily mean that human involvement is to be removed altogether. And it added, breaking the client's requirements down into a series of legal steps that will achieve the client's aim with the minimum of effort, expense, and uncertainty is the interesting and creative part of being a lawyer. Answering nutshell questions is the easy bit. Helen.
You've taken me back there, Dennis. I seem to recall Nutshells books in a variety of legal areas for beginners. Do you remember those at all?
Yes, I do. I'm not going to pretend it. I did use them, yes.
I seem to remember having one on contracts at the infancy of my career, because I didn't know much about that. But now, sticking with building that we've discussed today, the government announced last week that they accepted the findings of the Grenfell Tower Inquiry final report and will take forward all 58 recommendations. Now, these include sweeping construction, building and fire safety reforms and tough new rules on construction product safety, backed by a strengthened regulator to stamp out bad practice and drive higher standards. Under the proposals, industry will be held to account for failure with new regulatory measures to prevent a tragedy like the events at Grenfell Tower from ever happening again. Department investigations are to be launched for 7 organisations named in the report using tough new procurement powers, and stronger, more enhanced protections for social tenants, including by empowering them to challenge landlords and demand safe, high-quality housing. More than that, the government has apologised on behalf of the British state for its part in these failings and introduced significant changes to fix the worst issues exposed by the tragedy. Now, Dennis, set out the reforms in a list, because I know, as you've said,
yes,
you love the list.
My second list of the day. The reforms which were set out, as you know, were these. First, a new single construction regulator to ensure those responsible for building safety are held to account. Second, there'll be tougher oversight of those responsible for testing and certifying, manufacturing and using construction products, with serious consequences for those who break the rules. 3, there'll be a legal duty of candour through a new Hillsborough law, compelling public authorities to disclose the truth, ensuring transparency in major incidents and holding those responsible for failures to account. Next, stronger, clearer and enforceable legal rights for residents, making landlords responsible for acting on safety concerns. Next, empowering social housing residents to challenge landlords and demand safe, high quality housing by expanding the 4 million homes training programme. Government want to make it easier for tenants to report safety concerns and secure landlord action by taking forward the Make Things Right campaign. And finally, ensuring lasting transparency and accountability by creating a publicly accessible record of all public inquiry recommendations.
As well as changes in regulation, in December 2024, the government launched its Remediation Acceleration Plan, which sets out tough new measures to get buildings fixed quicker and ensure rogue freeholders are held to account. Now, again, in other news, a council's prosecution of a company has caught our eye, hasn't it, Dennis?
Indeed, it has. This is an unusual story. It doesn't happen that often. A local authority has been ordered to pay costs over an improper private prosecution of a taxi company owner. The defendant was the co-owner of Lucky 7 Taxis operating in the Midlands, which had applied for new operating licenses after the death of a co-owner in late 2021. The business did not realise that the licence granted by Newcastle under Lyme Borough Council lasted for just 6 months rather than 5 years, until the afternoon it was due to expire. The company made arrangements to run its Newcastle business by allocating bookings to licensed hackney carriages and subcontracting bookings through another of its entities based in Stoke to other Lucky 7 entities, or a separate Newcastle licensed operator, meaning it was compliant with the Local Government Miscellaneous Provisions Act 1976.
Now, Matt Lewin of Cornerstone Barristers represented the defendant, and he wrote about this. Crucially, at all times, the business had operated from a single premises, the address of which was specified in their Newcastle operator's licence over the border in the administrative area of Stoke-on-Trent. Newcastle under Lyme Borough Council took the view that this arrangement was unlawful and amounted to operating without an operator's licence in breach of sections 46 and 55 of the 1976 Act. So a prosecution was commenced in October 2022.
The prosecution was adjourned 3 times due to lack of court time over 2.5 years, but was finally listed for a 4th time at Cannock Magistrates Court, where the council actually offered no evidence. Lewin added, on the morning of the trial, the council belatedly conceded that it could not prove its case that the defendant had been operating in its own district, given that all of the antecedent arrangements for the dispatch of vehicles had taken place in a neighbouring controlled district. Exceptionally, the court granted the defendant's application under Section 19 of the Prosecution of Offences Act 1985 for an award of costs against the council, which is reserved for cases where one party to a prosecution has incurred costs as a result of an unnecessary or improper act or omission by another party to the proceedings. Interesting.
It's certainly rare, Dennis, isn't it? And one of interest to our litigators, no doubt.
Yes, very much so, very rare.
So now from litigators to family lawyers. The Family Justice Council has developed guidance to support legal practitioners in recognising and addressing the needs of neurodivergent individuals in the family justice system. The guidance highlights the impact of failing to accommodate neurodivergence, which can prevent fair participation and compromise justice. It also provides best practice recommendations, identifies common challenges neurodivergent parties face, and outlines reasonable adjustments that should be considered by practitioners. The report states that people who are neurodivergent can sometimes be regarded as disordered or in need of a cure. However, this is not the case. Their brains are simply different and not lesser. Neurodivergent people, like everyone, have particular strengths as well as areas they can find difficult. In the family justice system, it is up to practitioners to find ways to support neurodivergent people.
Well, yes, quite so. And the evidence available suggests that neurodivergence is overrepresented among court users, and the fact that it is often underdiagnosed is likely to further mask its prevalence in those accessing family justice. And the report reminds us that failure to recognise and take into account neurodivergence impacts upon children and families within the family justice system in 2 key and intertwined ways. First, assessments undertaken before, during and after proceedings or as part of dispute resolution. And second, barriers to participation in proceedings, which in turn restricts access to justice and to a fair trial. Failure to recognise and accommodate neurodivergence within the family justice system leads to parties, witnesses and children not being able to fully participate in proceedings and dispute resolution. And importantly, this potentially compromises their rights under Articles 6 and 8 of the European Convention of Human Rights, and also Articles 4 and 12, the rights under the United Nations Convention on Rights of the Child.
Well, the guidance is underpinned by ample academic research, which highlights several barriers neurodivergent individuals encounter, and these include, but are not limited to, stigma and misconceptions, stereotypes about aggression and lack of empathy or relationship avoidance, communication differences. So some individuals may struggle with verbal communication, eye contact, or indeed processing complex language. Sensory sensitivities, court environments may be overwhelming due to lighting, noise, smell, it's an unfamiliar setting. Emotional regulation Individuals may experience heightened anxiety, difficulty with change or sensory overload. And then you've got courtroom participation, long proceedings, rapid questioning, and unfamiliar legal terminology can certainly hinder engagement. And the Justice Council advises that practitioners should consider whether someone may be neurodivergent at the earliest stage. And they say a useful checklist is Toolkit 10, Para 2.2, within the Advocate's Gateway, which is identifying vulnerable witnesses. Though it bears highlighting, whilst the checklist may assist in identifying individuals who may be neurodivergent, it does not act as a screening or a diagnostic tool. So it suggests that practitioners should ask key questions to understand challenges, things like difficulty with reading, concentration, or sensory sensitivities, and seek additional information, including medical or educational reports if they're needed. And then, of course, you've got making reasonable adjustments. Now, per Lady Justice Hallett in R. and Lumbemba, that case at paragraph 44 made it very clear that advocates must adapt to the witness and not the other way round. And practitioners are also reminded of the very recent guidance by Mrs. Justice Levin on intermediaries, and that's the case of West Northamptonshire Council and Kay and Oars, and that was a 2024 case. Just got my mouth around all of that, Dennis, somehow.
You succeeded.
Thank you very much. And on that note, that's it for another edition of the podcast. You can read more on the items discussed today and many more besides by going to bulletin number 8, available on the LLG website now. So it's goodbye from me.
And from me too. Bye now.